Thanks everyone for taking some time this morning to join us. We have a lot of good information to go over today, but I just kind of want to start off by introducing who we are. Me and Tammy Zilske, like Kyle said, we're the presenters today. So I am an attorney here at Steinbacher, Goodall, and Yurchak. I'm a certified elder law attorney, and I'm certified by the National Elder Law Foundation. And I work primarily in our long-term care planning departments and also our estate administration departments. So me and Tammy work a lot together with individuals who are mainly concerned about protecting their assets if they would need long-term care down the road, or getting their estate planning documents in order to make everything go smoothly if something were to happen to them. But the good thing with working also in the estate administration department is I get to see the flip side of all of that planning, and I get to work with their beneficiaries and really see how good legal planning during your life really does assist your beneficiaries and make the process a whole lot easier after you pass away. And as I said, I work a lot with Tammy Zilske. She is one of a few certified Medicaid planners here in Pennsylvania. So we help individuals not only pre-plan, but also if they're already in a crisis, they're in the nursing home or they're looking at long-term care, we help them through the complicated Medicaid application process, make sure everything goes smoothly with them. And she has years and years of experience, and she's really great to work with. All right, so today we're going to talk about tricks to beat death and taxes. And like Kyle said, there's really only two things in life that are certain: that you're going to pass away and that the state's going to try to tax you when you do so. So unfortunately today, I don't have, the ultimate trick to beat death.
Says, relax, I'm from the IRS.
Yep.
Death and taxes have merged.
Yep. So I wish I had that for you today. But what we're going to talk about is we're going to talk about the legal process after you pass away. And I'm going to give you some tricks on how to make that process easier for your beneficiaries and possibly help them avoid some taxes along the way as well. All right, so what are we going to cover today? So we're going to cover the probate process. We're going to cover how to make sure that your wishes are followed after you pass away. How can you protect your family after you pass away? And then Tammy's going to talk about how you can, what planning you can do now to help save some money later, not only if you need long-term care, but then whenever you pass away from taxes. All right, so what is the probate process? Probate is really just the legal process where, whoever you appoint as your executor, they really go to the courthouse and, the court really determines what is your last will and testament. If you have something signed, that's presented to them. They make sure that it meets all the legal requirements, that it is in fact, your last wishes, it's valid, and it is your standing last will and testament. And it's also the process where your executor is formally appointed. Now, kind of on the flip side of that, if you don't have a last will and testament, it's also the process that helps determine who your beneficiaries are. Who is the next in line that's going to receive your property. So after they admit the will and they make sure that it meets all the legal requirements, everything, all the formalities are met, what they do is they issue what are called letters testamentary, or if you don't have a will, it's letters of administration. And you probably heard of these called a short certificate. So anytime you pass away and you have an account in your name, what the bank is going to do is they're going to freeze it after you pass away, and they're going to require your executor to have a short certificate. Well, that's what they get through going through this process. And after the letters testamentary are granted, they'll give them a formal form that basically says, okay, this person is your legal representative. They have the power to deal with all of your accounts and make all of those decisions after you pass away. So just some terms for you guys. So if you do have a last will and testament, that individual that you appoint to really handle everything for you, that person is known as your executor. But then if you pass away and you don't have a last will and testament, the court will actually appoint somebody in that role for you. And we'll talk about why that might not be a good thing, because the court kind of has a default designation and an order of who gets priority. And that might not be the individual that you trust or that you would really want to handle that for you. But that person is really known as your administrator because they're appointed by the court. So what happens if you pass away and you don't have your wishes outlined and you don't have a last will and testament? Well, that's where the state is actually going to make a last will and testament for you. So there are statutes in Pennsylvania that actually decide who's going to get your property if something happens to you. And it's not going to be probably who you'd want to receive the property. Because one of the most common misconceptions I hear is, well, if something happens to me, everything will just go to my spouse or it'll go to my kids and it'll be fine. I don't need a will. Well, we're actually going to go through some scenarios here about how that could actually go really wrong. And it might not be the case that everything's actually going to get to your spouse. So our first example, John and Jane Doe are married, and Jane dies and didn't have a will. Okay, and they both have a child. It's their joint child from their joint marriage. What happens? Well, John gets the first 30,000 as the spouse, and he gets one half of everything else. So you see there, even though he's the spouse, he doesn't automatically get all of Jane's assets. And then the child is actually entitled to the other half. So you can see how that can become problematic, especially if there's real estate. John's living in the house. He's only entitled to 30,000 and half of that house. It doesn't all go to him. So there would have to be some planning at that time or some agreements made to try to get everything over to your spouse. And then another scenario, so say John and Jane are married. Jane was married previously and has her own child prior to the marriage. Jane dies and didn't have a will. Well, this actually changes it entirely because it wasn't a joint child from the marriage. John actually only gets one half of the estate. He doesn't automatically get that other 30,000, and the child automatically gets the other half. Okay, so you can see where all of this could have been avoided if Jane would have just signed a last will and testament saying, hey, I want everything to go to my husband, John, because then he wouldn't have to work anything out with her child, the stepchild. You can imagine how that might cause some tension or some issues. And then he wouldn't have to reach any sort of agreement with his child either to try to get the other half of the estate. Now, where do you go through this probate process? You always have to probate in the county that the decedent last resided. So it's wherever they had their last principal residence. And a lot of times that's going to be listed on their death certificate. You get those from the funeral home and it'll say, they were a resident of Lycoming County or whatever county they resided in. And that's the courthouse that you would have to go to probate. Now, how does the probate process work? So we talked about presenting the last will and testament, getting the executor appointed, getting those short certificates. But what happens is after you formally get appointed and the courthouse actually formally opens an estate in their file, there's some legal requirements that are then triggered. So one of those requirements is you have to send out notices to the beneficiaries. So if you have a last will and testament, that's notice to everyone in the will. It's notice to the surviving spouse, if there is one, and any children. So this is where it gets a little tricky. So some people say, well, I don't want this child to get anything, so I'm going to leave them out of the will. Well, the statute says that they still have to be notified anyway, even if they are left out of the will. So it's children and spouses and anyone in your last will and testament. And if you don't have a will, it's really just your next of line beneficiaries, whether that's your spouse and your children at that point or nieces and nephews. They all have to get a notice that you're passed away. And what that does is that really helps protect them as beneficiaries. So your executor can't, try to steal money for them or not give them their required distribution from the estate. It really just puts them on notice that, hey, you might be entitled to something and you might want to follow up with the executor about that. And then you guys have probably also saw in the newspaper advertisements for the estate. So this is another legal requirement. You do have to advertise in a newspaper that's in general circulation in the county where they resided. And you have to run that advertisement for 3 consecutive weeks. And what that does is that really puts any creditors on notice that they have 1 year from the time that they would see that advertisement in the newspaper to let the executor know that, hey, I have this unpaid bill, I have this claim against the estate, I want some money from the estate. because, can you imagine if you didn't advertise and put them on notice and you have a creditor trying to come after assets 10 years after the estate's been finalized, there's no money left, everything's been distributed, that would really be a nightmare. So this legal requirement really tries to put a statute of limitations on creditors being able to come after estate assets, because they would only have that 1 year from the time that advertisement runs. And then you also have to send notice to the Department of Human Services anytime the person that passed away is over the age of 55. And what that does is that really puts the Department of Human Services on notice that if they ever paid for Medicaid benefits, if they were in a nursing home or they received care where the state was helping to pay for some of that care, they're actually going to have a lien against the estate for the amount that they paid. So, for example, if you were in a nursing home for 5 years, Medicaid paid for 4 of those 5 years, they're going to try to recoup some of those funds that they paid. And so they're going to send your executor a bill for $400,000 or whatever that amount is. And that's where, some of the planning that we're going to talk about a little later on is going to help protect from that lien, because they can really only come after assets that are in your name alone after you pass away. So this makes people a little bit nervous because they're like, oh, what if they go after my beneficiaries? Can they make my children pay that large bill? And they can't make your children pay it. It's really just whatever assets you have at the time that you pass away that are in your name alone. All right, so after you get appointed as the executor, you get the short certificate, you send out the notices, you've advertised. The next step is you really need to inventory the assets, excuse me, and appraise any assets, because you're going to be looking at, what is the value of these assets as of the individual's date of death. So you always want to make sure that you know about stock, savings bonds, safe deposit boxes, real estate. You need to really gather everything that the decedent had and really know what it's valued at that point. And then once you have a good idea of what is owned, then you have to take a look at, well, what are the outstanding debts and expenses? Is there a mortgage on the property that needs satisfied? Who's getting the real estate? Are they going to take over that mortgage? Does it need paid out of the estate? And then there's always a priority for creditors as well. So I always tell people, well, don't, just start paying bills, because they might be bills that don't need to be paid if there's not enough assets left in the estate. So for example, costs of administration are first priority. So that would be, attorney's fees, funeral expenses, any other burial expenses, they all get paid first. And then if you have like a large medical bill or something that would be a lower priority, they might not get paid based on the assets that are left after the first priority expenses get paid. So it's always good to talk to an attorney before you just start paying bills, just to make sure that you're paying them in the correct order. Now, what's the time frame for distributions from an estate? And there's really no good answer for this, because each estate is a little bit different. So some estates go smoothly, and they can be distributed right away. Everything's been paid for, the taxes have been paid. And then some estates, you have those beneficiaries that just don't get along. The executor and the beneficiaries don't get along. They might end up in a legal process. So it really does vary. But the key thing to take away is, in most situations, you don't have to wait until everything is finalized to get a distribution. You can do partial distributions along the way. The thing to keep in mind is you have to make sure that you have enough for any inheritance tax, and we're going to talk about that in a minute, and any of the expenses. Because if you were to distribute the assets and none of that was paid, they're going to be coming after you personally as either the executor for liability for distributing it, or the beneficiary for receiving it without them getting paid. So you have to be careful with distributions, but you don't have to wait until everything is finalized to get some distributions. And there's two ways to kind of account to the court of how assets have been distributed. Again, if everyone gets along in the estate, there's not really been any arguments, everything's cut and dry. A lot of times you can do an informal accounting to the court. basically just an agreement signed by all the beneficiaries saying, okay, I received this distribution. I agree this much was in the estate, and I agree that everything is finalized. And honestly, most of the estates that I work on, we're able to do it informally. But you do have, some of those estates where a beneficiary thinks that, something else should be out there, or somebody stole something prior to them passing away. And they always really want a formal accounting approved by the court. So, that's kind of the flip side, is if anyone questions it, you might need to file something formally and have it approved by the judge. All right, so when do you have to probate? Well, there's only certain assets that really trigger the probate process. And really that the biggest thing I see is if you own real estate. So if you have real estate that's just in your name alone, that's always going to trigger the probate process, no matter what that real estate's worth. Even if it's in bad shape and it's only worth $20,000, you're still going to have someone appointed to be able to sell it, or tear it down, deal with the real estate. And then also, anything that you own is what's called tenants in common. So I see this a lot with family cabin properties, a family farm. Maybe your parents passed away and left it to you and your siblings, and you each own a third. Well, there's kind of several different designations in Pennsylvania, and one of them is what's called tenants in common, which basically means whenever one of the joint owner passes away, their share goes according to their last will and testament, or if they don't have a last will and testament, it goes according to what the law says. So because it goes through your last will and testament, you do have to have someone formally appointed, and you have to go through the probate process to be able to transfer that 1/3 interest. And then also for bank accounts and other assets, anything over $10,000 is going to trigger probate to liquidate those. And stock in your name is always going to require probate, even again, if it's only worth $20. And that's one of the most annoying things I think I've run into in estate administration, is trying to get stock liquidated. So that's always going to require probate, no matter what the value is for that. Now, what are some ways that you can avoid this whole process? Because I know probate is one of those terms that everyone is like, I don't want to have my beneficiaries have to go through probate. Isn't it expensive? And everything becomes public record. Well, there is certain ways that you can avoid probate by how assets are titled. So one of the ways that we look at doing it is by establishing a trust. And a trust can either be revocable or irrevocable. It can also be a grantor or non-grantor. We're going to kind of go through what all these terms mean. And then one of the trusts that we use a lot, because it has kind of a double benefit to you guys, is the asset protection trust, because this is really the trust that you set up if you're worried about protecting assets for nursing home care, or if you have to hire caregivers down the road. Because the good thing is it really helps to shield those assets not only during your life, but then because it's owned by a trust, your beneficiaries don't have to go to the courthouse. They don't have to go through the probate process. So it has that double layer protection both during life and after you pass away. All right, so what are some of the common objectives? I kind of just hit on this, but one of the big things is probate, because again, probate is only assets that are in your name alone. So if there's a joint owner, or if it's owned by a trust, that doesn't trigger probate, okay? The trust document just says where the assets are distributed if something happens to you. And then the biggest one too is long-term care protection. And Tammy's going to talk a little bit more about that later, but we utilize a trust a lot to get assets out of your name so that it's not countable if you were to go in the nursing home. And then a good thing about trust too is there is a certain layer of creditor protection, especially for your beneficiaries. So a lot of people say, well, I just want to get all of this out of my estate and I want to get it over to my kids now. That way they don't have to worry about any of this. Well, what if you transfer your house to your child and they get into bankruptcy, or they're, getting a divorce? Now, all those assets that you transferred to them are subject to all of their creditor issues. So the good thing about a trust is it helps get it out of your name, but it doesn't open it up to any sort of liability from any of the beneficiaries that you would name in the trust document. So that's also kind of a benefit. You can get it out of your name, but you don't have to worry about divorce or bankruptcy, anything like that with whoever you name in the document. And then we're going to touch a little bit on the federal estate tax. This isn't as much of a big deal as it used to be, because right now the limit is 11.58 million. So if you pass away with more than $11 million in your estate, your beneficiaries might be looking at a 40% federal estate tax. But again, the limit used to be a lot lower, so we used to do a lot more planning to help shield estates from this tax. But now, between you and your spouse, you can actually have $22 million before you would be hitting this tax. So if it's a concern, just know there are ways to avoid it, but it's really not as big of an issue as it used to be. All right, so even though a trust does avoid the formal probate process, you don't have to get the court involved, you don't have to file anything at the courthouse. It does have some administration on the back end, and it is sort of a probate-like process. It's just more informal than having to involve the court. So you do have to still send out notices to the trust beneficiaries. You know, they're entitled to see a copy of the trust after you pass away, review the terms, make sure their interests are protected. And then we always recommend that you do also advertise the trust in the newspaper, just like you would do with the estate. And again, that's going to help clear out any of those creditor issues. Now, a good thing with a trust too is that even has an extra layer of creditor protection during your life too. So even if you advertise, some of those creditors might not be entitled to payment from the trust, even if they were to come forward. But it just helps kind of get them to come out. That way they can't try to come after the trust 10 or so years down the road. And then you always have to be thinking about income tax and inheritance tax, because more than likely the trust is going to have some final income taxes based on the assets that are in the trust. Excuse me. And then there's always inheritance tax as well. And again, we're going to talk about that in a bit. Now, another way to avoid probate is any sort of account that has a beneficiary designation. So life insurance, IRAs, retirement accounts, sometimes investment accounts you can set up with a beneficiary. The good thing about that is you don't have to probate to receive those assets. Those assets are going to go directly to the beneficiary that you have listed. And because of this, it's always good to keep those beneficiaries up to date and to know who you have listed, especially, you know, if you have a former spouse potentially listed on your life insurance or your retirement account, you want to make sure to get that updated because, you know, even if you have a last will and testament that says, I want everything to go to my new spouse, if you have your former spouse listed as a beneficiary on that other account, the life insurance, the IRA, it's unfortunately going to go to them regardless of what your will says. So always take a look at your beneficiaries and know who you have listed. All right, so we just have an example here. So husband and wife name each other as the sole beneficiary of their IRAs. Husband dies first, but wife never updated her beneficiary designation and didn't name a contingent beneficiary. Wife dies. Wife's IRA will actually pay to her estate because there is no named living beneficiary. And why is this problematic? Why is it a problem that it would pay to her estate? Well, first of all, that's going to trigger probate, okay, because it's going to pay to the estate. And it's also going to open it up to any of the creditors of the estate. So where we had talked about the Department of Human Services being able to come back after estate assets, or any of the other creditors, unpaid medical expenses, mortgages, all of those creditors are now going to be able to attach to those IRA funds because they're now part of the estate. So I never recommend naming the estate as a beneficiary. Always make sure that it's updated with a living individual and somebody that you would want to receive that account, because if it goes directly to the beneficiary, they don't have any of those creditor issues. Now, there is some caution that I would like to give you guys before just adding joint owners to all of your assets. So again, a lot of people say, well, I'll just add my son to my bank account. That way he can write checks or it can go to him if something were to happen to me. Well, that's always not always the best option, because it really opens it up to their creditor issues, like I was talking about earlier. So say you add your son to your bank account, again, he gets a divorce. That's going to be considered all his money in that divorce action, and you could potentially lose that money. Or if he were to pass away before you, which, you know, may happen, you know, he might be in a car accident or something, you're going to have to be paying Pennsylvania inheritance tax on your own money. okay, because he's a joint owner. And, he might not distribute it the way that you want after you pass away. Because I hear a lot too is, well, he'll be fair. He'll give everything, he'll split it half with his sister, or, he'll do what I want. Well, when it comes to money, you'd be surprised that, once that individual passes away, he's like, nope, that's my money. I'm going to keep it. I don't care what dad said. So it's always important just to kind of keep those in the back of your mind before you start adding joint owners. Anyone who's not your spouse as a joint owner on your account. Now, for spousal situation, I do recommend that you do have those assets joint, because that's going to avoid your spouse from having to probate if something happens to you. So bank accounts, real estate, it's always good to make sure that those are owned jointly between you and your spouse, if that's something that you guys would feel comfortable with. All right. So another option with real estate is that you can transfer the real estate to your children, but retain what's called a life estate. Now, the problem with a life estate is it does avoid probate, because basically what a life estate says is, well, I'm giving away my property now, but I want the right to live there during the duration of my life. They can't just kick me out. I'm here for my life, and then it goes to them. Well, the good thing about that is it does avoid probate, but the problem is if you want to sell that property during your life, now you have to get permission from all of those individuals that you transferred it to. It's no longer your property just to do with as you please. You have to get everyone to sign off on everything. And again, because it has that designation of just going to whoever you list, it doesn't pass according to your will. Okay, so that might be a problem if you have it going to one person, but your intent was that they would then split it with everybody else, because there's no guarantee that they'll do that after you pass away. And it's really important to know what you own, because again, things tend to creep up that people forget about. And one of the biggest thing is savings bonds and stock that I see. People will have an old stock certificate, they'll forget about it. The beneficiaries will find it in the house when they're cleaning everything out. And then there has to be research and probate and trying to find out, where is this stock now? So it's really important to try to keep good, accurate records during your life. It's really going to make everything a lot easier on your executor or your administrator after you pass away, because it really is going to be, a find and seek mission if they don't really have any idea of what you own. They might have to send letters to all the banks in the county trying to say, well, did he have a bank account at there? Is there a safe deposit box out there anywhere? So always just try to keep a list of your assets, try to keep it as current as possible, because it's really going to help whoever takes over after you pass away. Or even if you were to get sick, it's really going to be a help there as well. And then what we like to do is we always check Pennsylvania Treasury Department unclaimed property, because what this is, if you ever received a check that you didn't cash, or there was a refund and they couldn't find you, you moved, after a number of years, what they'll do is they'll send it to Pennsylvania unclaimed property, and it's listed under your name and your address. And a lot of times they'll say, under $100 or over $100. So we always try to check that as well, because a lot of times dividends or things like that will go to unclaimed property for the individual that passed away. And we can always try to gather that as part of the estate as well. And, I can't stress this enough, but it is good to get all of your planning in order, ahead of the crisis, before you become sick, or, before you pass away, because, it's going to make everything a whole lot easier for your beneficiaries, because again, they're going to know where everything pays, who's going to be the decision makers, what assets you have. So it's really important to get your estate plan in place and to meet with an elder law attorney to really do that, because they're going to be knowledgeable not only to protect during your life from nursing home care, but then help administer it then after you pass away. Now, I did talk about assets sort of being frozen after you pass away. So, really, bank accounts are the only thing that's really going to be frozen, really, after you pass away, because the bank's going to want that short certificate. So, but if you have a joint owner on the account or anything like that, that's not going to be frozen. But again, once your executor gets appointed, they can close that account, they can put it in part of the estate, they can start paying their bills. So I wouldn't worry about the assets being frozen, because a lot of times creditors and the funeral home, they always understand that there's a process after you pass away to get access to the money. So a lot of times, they're willing to work with your executor to send payment whenever they're able to get appointed and to close the account and really get access to the funds. But again, the funds aren't locked in the estate forever until it's finalized. Each, like I talked about, each estate is a little bit different, but a lot of times you can get partial distributions along the way. And also, we've been talking about probate, but the cost really is not that expensive. So, whenever I talk about setting up a trust to avoid probate, a lot of times, if all of your assets are in Pennsylvania, I won't recommend a trust just for that purpose. I mean, if you're looking for long term care protection or you have troublesome beneficiaries with creditor issues, I mean, those are all good reasons to set up a trust. But the cost of probate is usually only a couple $100s in Pennsylvania. And what they do is they base it on the size of your estate, so the value of your probate assets, the number of pages in your will, how many short certificates your executor feels that they'll need for companies, for the bank, to send to them. And then if you name multiple people as your executor in your will, they do all have to serve jointly. But say one's out of state and they say, well, I really don't want to serve, the other person can handle it. They can actually step down and sign what's called a renunciation. So your executor would have to have all those documents signed and present to the court all at the same time. And that's all going to be part of how much it costs to probate in Pennsylvania. But again, I've never seen the probate fee be outrageous, usually a couple $100s. And then you do have the advertisements in the newspaper. A lot of times they charge per word. So it depends, how long the name of the trust is or, what all you have to put in the advertisement. But again, they're not really expensive as well, a couple $100s. All of this is paid out of your assets after you pass away. And then the formal accountings, usually they're not real expensive either, but we always try to avoid them as well and do it informally. And they're not always necessary. But whenever we do have to file an accounting with the court, there are filing fees for that. You have to send notices to different individuals. So that can be about $100 to $300. Now, the good thing about trying to avoid probate, though, is you do retain some of your privacy. Now, there's always going to be some part that's on record at the courthouse that if someone's nosy, they could always go and they could look at. But probate makes it a little bit more public because they're going to have a copy of your will on file. They're going to have a copy of everything that's filed on behalf of the estate, who the beneficiaries are, the inheritance tax return, all of that's going to be public record. But even with non-probate assets, you still have to file the inheritance tax return. So you can't ever avoid things being public record entirely when you pass away. But with a trust, you do retain a little bit more privacy. And with joint accounts, you have privacy. So it's not as open as the probate process. And then what we like to do here whenever we help people administer estates is we're always worried about identity theft and creditor protection, things like that when you pass away. So we always send notice to the three major credit reporting agencies asking for a credit report, asking them to freeze all of your credit information so no one tries to steal your social security number or any of your public information. We don't want someone opening up a credit card after you passed away. And then also the Department of Motor Vehicles, that way they can't steal your driver's license information or any of that information to steal your identity. And then, some documents you do want to keep, like tax returns or anything like that, that's important. But if there's anything else that you really don't need to keep, but it has sensitive information, such as social security numbers, anything like that, it's always good to shred that after someone passes away. Now, how do you make sure that your wishes are carried out? So, the biggest thing that I can stress is have a plan. So, whether it's signing a last will and testament, or if you think a trust might be in your best interest, always have it in writing, have it laid out exactly how you want it. Make sure you know who's going to be doing what if you get sick or if you pass away. A plan is always, the starting point. It's the firm foundation that makes everything go a lot more smoothly after you pass away. And then you also want to know what you own, how it's titled, because you don't want to have your executor trying to do a scavenger hunt for all of your assets after you pass away. Because it's going to cost the estate more because they're going to have more attorney's fees and filing fees trying to figure things out. And it's going to take a lot longer for them to be able to get their distributions as well. And then always review the types of ownership, especially if you own property jointly with, again, your siblings or anybody else. Always know whether, it's going to go back to the other joint owners, whether it's joint tenants with the right of survivorship, or if it's tenants in common, like we talked about, where your share is going to follow your will and your estate plan. Because it's always important to know how that property is going to go in Pennsylvania. And then if you do own property jointly with your spouse, that's called tenants by the entireties. And I always do recommend that for spousal situation like I talked about earlier. If you have real estate and you feel comfortable adding your spouse as a joint owner, that's going to guarantee that when you pass away, that property goes 100% then to your spouse. And again, review those beneficiary designations. Make sure you know who you have listed on your IRAs, your life insurance. If you can set up an account as a transfer on death and list a beneficiary. All of those are going to be good ways to avoid probate. It's going to avoid the asset going to your estate or an ex-spouse or a parent that's passed away or, somewhere that you wouldn't want it to go. So always make sure that those are updated. And a lot of times that's just a form that you can reach out to the company and say, hey, I want to know who my beneficiary is. I want to get that updated. And they can get that updated for you. All right, so there are some taxes that we have to be aware of when an individual passes away. So we're going to talk about the Pennsylvania inheritance tax. We don't, again, have to worry as much about the federal estate tax anymore, but it's still there, so we'll talk about that. And then income tax. So those are really the three taxes that your executor and your beneficiaries have to be concerned about. So what is the Pennsylvania inheritance tax? So this is a tax that I find a lot of people really aren't aware of. It's really not advertised out there that this tax is there, but it's really a tax on receiving assets after an individual passes away. It's a one-time tax. You don't have to pay it each year. It's just one time. It's based on the value of the assets on the date that the individual passed, and it's based on your relationship to the decedent as well. Now, just a little fun fact for living in Pennsylvania, we were actually one of the first states to impose the tax, and we're actually only one of a few that still has it, unfortunately. So I tell people if you want to avoid the tax and have some good weather, maybe go down to Florida because they don't have the inheritance tax and they have a lot better weather. But Indiana, Iowa, Kentucky, Maryland, Nebraska, Pennsylvania, all of those states, there's going to be some form of an inheritance tax when you pass away. And one of the misconceptions I hear is, well, if I have everything in a trust or a beneficiary for an IRA or a joint owner, that avoids the inheritance tax too, doesn't it? No, so that's not the same thing. So even though something might not have to go through the probate process where you go to the courthouse, it's still going to have that inheritance tax that your beneficiaries are going to have to pay. And there's only really a few assets that are exempt from that and a few ways to avoid it. They're always going to try to get that inheritance tax, and just the default is that it's going to be due after you pass away. Now, the rates are going to depend on who's receiving the asset. So your spouse, or if you leave it to a child who's under 21, they don't have to worry about the tax. That's actually 0%. So that's why I always recommend that if you want things to go to your spouse, add them as a joint owner because it goes directly to them without probate, and they don't have to pay the Pennsylvania inheritance tax. It's 0%. If you leave it to children or any sort of lineal heir, grandchildren, great-grandchildren, they have to pay 4.5%. Siblings are 12%, and then anybody else, nieces and nephews, family, friends, they're 15%. Now, one thing to keep in mind is charities don't have to pay this. So sometimes an individual will say, well, I want to leave, something to a charity. A good thing that I recommend is maybe an IRA or something that would have income tax plus inheritance tax on it, because the charity isn't going to have to pay income tax. They're not going to have to pay inheritance tax, and they don't have to worry about any sort of those IRA rules with distributions or anything like that. So it's always kind of important to keep in mind, well, if my beneficiary receives this, what's their tax liability going to be? So maybe I should leave them something that's exempt from tax and leave the charity something that they would have to pay tax on. Now, the only type of asset that's actually exempt from inheritance tax is life insurance. So, again, if you have a beneficiary that's going to be in that higher tax bracket, like you want to leave something to a niece or a nephew and they're going to have to pay 15% tax, it might be better to leave them a life insurance policy that's tax free and leave, your children who are going to pay less tax, another asset. So, that's always important to keep in mind too, is how much inheritance tax are they going to have to pay? Yeah, and like I said earlier, generally everything is going to be subject to inheritance tax except for life insurance. So, regardless of whether it's owned by a trust or owned jointly, they're going to try to get that tax regardless of what type of asset it is, except for life insurance. So even some things that a lot of times you don't think about is, jewelry, things in your house, paintings, anything that can really be valued is something that, your beneficiaries are going to have to pay tax on. Now, one of the good things that I've found with the Department of Revenue for personal property and furnishings in your house is a lot of times they won't make it your beneficiaries get it appraised unless it's a coin collection or jewelry or famous painting, something that's going to be a collector's item. But if it's just, clothing, run of the mill furniture that might, not really have an antique value or anything like that, a lot of times you can just say, oh, well, there was personal property, but it's worth maybe $500 total. And a lot of times they really don't question that, but they are going to question the bigger ticket items, gun collections, anything like that, that if you were to sell it, it would bring in a lot of money. That's what your beneficiaries are going to have to get appraised. Annuities, IRAs, they're all going to be subject to it as well. And one thing that we run into a lot too is the Department of Revenue doesn't want you giving away all your property on your deathbed and then being able to avoid the tax. So, what they did is they said any assets that you transfer within the last year before you pass away, anything over $3,000, they're actually going to bring back in for inheritance tax purposes, and your beneficiaries are still going to have to pay that inheritance tax. So, this is one of the things that I get the most arguments about whenever I represent estates. They say, well, dad gave that to me 6 months ago. I'm not paying tax on that. Well, unfortunately, they don't want you giving away all of your money and then avoiding the tax. So, within that year, if you give it away and it's over $3,000, just know they are going to still tax that for your beneficiaries. And then trusts, depending on how they're set up, the majority of them are still going to be subject to inheritance tax. But it's really going to be the provisions of the trust, because there are certain ways that you can set it up where if you transfer assets, you essentially give up all of your control over the trust and the management and everything. And you survive that year after transferring it to the trust. Sometimes it can be set up where it does avoid that tax, but we always have to be careful with this, and we have to take a look at, well, if you give up this control, it might have some income tax liability to you during your life, or it might have some other tax consequences. So we have to take a look at, well, what's the lesser of the two evil? Are you going to have to pay 15% capital gains tax if we put real estate or stocks in here? Or are your beneficiaries just going to have to pay a 4.5% inheritance tax? So those are all things that we take a look at: who your beneficiaries are, what's the income tax liability, is it really worth avoiding the inheritance tax at that point? And then we did talk about any assets that you own jointly with your spouse. If your spouse survives you, that is exempt from inheritance tax. So you don't have to worry about your spouse having to pay anything when you pass away. It just all goes to them inheritance tax free. Now, with spouses, so the good thing is because spouses are exempt from inheritance tax. Now, this is different if you guys own a trust. So just keep in mind, this is just if you guys own property outright, jointly, there's no trust involved. So if spouses own assets jointly, a lot of times you don't have to file a Pennsylvania inheritance tax return because everything is exempt. So you don't have to report it, don't have to pay any tax. The one exception to this is if you say have real estate in your name and you just add your spouse on within that year before you pass away, that kind of triggers the need to file a return, even though there wouldn't be any tax due. So you still have to report it, but just say everything goes to your spouse. So inheritance tax returns, I always like to look at them as a legal document. They are very complicated. There's a lot of rules involved, a lot of exceptions that you can take and things. So it's always good to reach out to an attorney if you're doing this on behalf of someone, because you never want to try to navigate this yourself, because it will a lot of times get you in trouble because you won't know of all the exceptions. You won't know if you have to file or not. So it's always good just to reach out and get that opinion on whether an attorney feels that it needs filed or not. All right. And then we talked about life insurance being exempt, but if you were to transfer anything to a governmental entity after you pass away, they don't pay tax on the assets going to them. So that's exempt. Again, charitable organizations, if you were to leave an IRA to a charity, they won't have to pay tax on that. Any sort of lump sum death benefit that you would either get from Social Security or the Veterans Administration. The good thing about that is that's inheritance tax free. Or if you would get any sort of burial benefit from the US Railroad retirement, there's no inheritance tax on that. Now, how do they calculate the tax? So they do take a look at what all property you owned at the time you passed away, any gifts within the last year, and they're always going to value that on the date that you passed away. So for real estate, you can get an appraisal, or they can use the tax assessed value that the county uses for real estate taxes. But they're always looking at that snapshot date of what it's valued at on the date that you pass away, and then it's based on whoever receives the asset. Again, if it's your kids, it's 4.5% of whatever it's valued at on the date that you pass. Now, who has to pay the tax? So this is where it gets a little bit tricky as well, especially if you leave, an IRA to your son, but then you leave everything else to your daughter. How's the tax really being paid? And that's really going to be controlled by what your will says or how you have it designated otherwise. The default really is that it just kind of comes off of the top, and then your beneficiaries get everything that's left over. But it gets tricky, if you leave, this percentage to this person or leave something else to another person. You can prorate the taxes where each beneficiary is kind of responsible for the inheritance tax on the assets they receive. So that's kind of an option as well. You can allocate them depending on how everything's going to be distributed. Yep. So if it's not provided otherwise, if it's property that goes through the will, it's really just going to, like I said, come off of the top with the general administrative expenses. And then the beneficiaries are just going to split the residue, whatever's left over at that point. Now, if it's passing outside of your will, like I said, real estate has a joint owner, it goes to them, or an IRA has a beneficiary. A lot of times, whoever's receiving that property is going to be responsible for paying the inheritance tax. Because a lot of times that's really only fair. If only one person's getting the asset, they should only have to pay their share of the tax on that. Now, who has to file the inheritance tax return? So that's really the job of the executor or the administrator, whoever's appointed by the court. Because, if they don't file it, that's where, if the Department of Revenue ever finds out about it, they could have liability placed on them, penalties, things like that. So it's really one of the things that the executor has to take care of as part of the estate. And it's really going to be one of their responsibilities to make sure that it gets done. Now, you do have 9 months after the individual passes away to get this filed. And the way that it works is actually if you make a prepayment on the inheritance tax, so say you have a good idea at 3 months that there's going to be $100,000 of taxable assets, you can actually make a prepayment within 3 months, and that actually gives you a 5% discount. Now, the important thing to keep in mind with the prepayment is it's always going to be an estimate, because I don't know any estate where you have all of the values back by 3 months unless everything's pretty much straightforward. But you get 5% on whatever you pay or the tax, whichever's less. So if you prepay $20,000 and the tax only ends up being $10,000, you get 5% discount on the $10,000. Okay. And then the rest you would get back as a refund, because they're only going to charge you what the actual tax is. Even if you pay more than that, you'll just get a refund on the flip side of it. Now, federal estate tax, again, we talked about the limit this year is 11.58 million. So right now we don't really have to worry about it. And this law isn't set to sunset until 2025. So this will be the limit for at least a couple more years. But we're always kind of keeping this tax in the back of our mind because it's always going to be dependent on who's in office, who's making the laws, because they can change it really at any time. And we've seen them change it throughout the years. It used to be 600,000, then it was 5 million. And then with the new tax law, whenever President Trump took over, it actually went up to 11.58 million. So it's always subject to change. So if you're close to about, the 1 million mark or close to that, it's always good to keep it in the back of your mind and maybe look at doing some planning to potentially avoid it in case it were to go back down. Because the rate for that, and that is just a federal tax that's paid to the IRS, it's 40% for your beneficiaries. Anything over that exemption is taxed at 40%. And the way that you report those assets, if you're close to that mark, is you do have to file what's called a federal estate tax return. It's a Form 706. And just like the inheritance tax return, that has to be filed with the IRS within 9 months of date of death. And you have to list all the values of the assets as of date of death, just like the inheritance tax return. But again, it's really only if you're close to that exemption, that's what triggers this return. You don't have to file it if you only have, $1 million, you don't have to file this return. All right, so what do you have to worry about for income taxes after you pass away? So there is always going to be a final personal income tax return that needs to be reported for the individual. So your executor will have to take care of filing your final income tax return. And then depending on whether you have assets owned by the trust or whether assets are liquidated and paid to the estate, that's going to trigger what's called a fiduciary income tax return, because after you pass away, any income earned on assets cannot be reported on your final personal return. It has to be reported under the estate or under the trust at that point. And that income tax liability is really then paid from those assets. So that's where you have to file what's called a Form 1041 and a PA 41. And a lot of accountants are really familiar with this. So we always recommend, if you are an executor or a trustee under a trust, always hire an accountant and talk to them about this, because what will happen is you'll start getting 1099s under the estate or under the trust, and they'll have to file something to report that after the individual passed away. Now, the good thing about trusts and estate assets is anytime you receive the asset and you pay inheritance tax on it, you get what's called a step up in basis. So for instance, say real estate. Say, you get this from your father, and back in the day, your father paid $5,000 for 30 acres of land, okay? And then he passes away and you receive it as part of the estate. You pay your 4.5% on whatever it's valued at the time that he passed away. So say at that time it's worth $200,000. Instead of paying capital gains when you sell it on the difference between 5,000 and 200,000, your basis is now going to be 200,000. So if you sell it for only 250 or 200,000 on the dot, it's saving you a lot in that capital gains tax, which is 15%. So that's why I was talking about, we always have to look at kind of the lesser of the two evils for the tax, because the inheritance tax triggers the step up, okay, which avoids the 15% tax. Whereas if you don't pay it, you wouldn't get the step up and you'd have to pay 15% capital gains. Okay, so 4.5 is better than the 15%. So that's all things that we take a look at. All right, so now I'm going to turn it over to Tammy, and she's going to talk about pre-planning, what you need to do if you're facing nursing home care to help save money for your beneficiaries.
All right, thank you, Brittany. So Brittany talked about the importance of having a last will and testament, and it really ensures that your assets will be distributed to the individuals that you want it to go to. But also really considering pre-planning, and the trust that she referred to earlier are the way that we do that. So one of the biggest risks is not necessarily what happens if I die, but what happens if I don't die and I get sick and I need care in a nursing home for a long period of time. And that's really where an irrevocable trust will ensure the protection of those assets so that they will be guaranteed to be there for you during your life, but also be distributed to your beneficiaries when you pass away. So pre-planning is definitely a way to avoid future liability costs, mainly for long-term care. And at Steinbacher, Goodall, and Yurchak, we have, like we'd mentioned earlier, certified Medicaid planners. There are actually less than 5 in the state of Pennsylvania, and our law firm does employ 2 of them, and I'm one of them. And then Kristen Doherty is another long-term care planner who's certified as a Medicaid planner, and she works in our state college office. So one of the things that Kristen and I are always concerned about is filing Medicaid applications at the appropriate time. So if you do find yourself in a crisis situation where you're in a nursing home and you need care, it's really important not to take advantage of having the staff at the nursing home file the Medicaid application for you, or you filing it yourself. Because there are very strict financial requirements to qualify for Medicaid. And oftentimes people will come to us 2 or 3 months after they filed the application and it's denied because of excess resources. And we say, we could have saved you $30,000 that you have to pay to the nursing home now. So my advice is, if you or a loved one finds yourself in a long-term care facility, call us right away so that we can take action and make sure that you are protecting as much as possible. The other thing is, there is a particular form you have to file for married couples, and it's called a resource assessment. And again, I see this happen often where people have filed on their own and they've not filed that resource assessment, and that guarantees a protection of assets for your spouse. So the other thing we have to think about in the estate planning that Brittany had talked about is making sure you have powers of attorneys in place. And so this seminar doesn't focus a whole lot on that, but we do have some seminars on our website that you can listen to that talk a lot about powers of attorneys and wills. But a power of attorney really allows you to designate an agent that's going to follow your estate plan during your life. So people often come in and say, I need to get a will done. And we counsel them on the importance of getting a power of attorney done as well, because that really ensures that while they're living, the person that they trust can pay their bills and make healthcare decisions for them. The other thing we wanted to mention about a last will and testament, in addition to outlining your beneficiaries, is the importance of a bypass clause. And this is very important in a marital situation where you name your spouse as beneficiary. We want to have a bypass clause that says that I give everything to my spouse, except in the event that they are in a long-term care facility receiving Medicaid benefits. And so a last will and testament is something that cannot be updated by anybody but you. So if you became incompetent and then your spouse is in a nursing home and your will leaves everything to them, we're stuck with that. But if we have this planning tool in place in advance with a bypass clause, even if you're incompetent, it will allow your state to pass over your spouse if they are in a nursing home. So that's a very important thing that we have in all of our last will and testaments at the law firm. And then this is so important too. We do recommend annual reviews with our office because situations change. You may have somebody listed as a power of attorney or an executor, and something's happened in their life where they really can't serve anymore, or your beneficiaries become disabled, and maybe they shouldn't receive it outright, but in a trust. And then also keep in mind that your beneficiary designations always need to be updated. So you may have a deceased parent listed on a life insurance policy or an ex-spouse. And so those things will not pass through your last will and testament, as Brittany outlined. You do need to make sure anything that has a beneficiary designation is updated to name the individuals that you would want to receive those assets upon your passing. And then the other thing we really need to think about right now are retirement accounts. And under the Secure Act, there are certain rules that would apply for people receiving your retirement when you pass away. So we can advise you on the best ways to outline your retirement accounts to minimize taxes. And then Brittany did touch base on this before, but I'll just again explain that transfer on death accounts, like investment accounts that say a transfer on death to an individual, are important, but like beneficiary designations, they need to be updated. Real estate, we have to make sure that the real estate is titled appropriately so that it does follow your wishes. All right, and then if you do have any minor beneficiaries, so if you're leaving anything to grandchildren, great-grandchildren, we want to make sure that your estate plan really does make sure that they receive it in the manner you want them to. So there are uniform transfers to Minors Act rules that you can leave it to them in custodians of care until they reach a certain age. And then we always also talk to people about pre-arrangements. This is not a fun conversation, but it is something that we all really have to be aware of. And setting aside money for burial expenses would really alleviate stress on your family members so that they're not having to worry about how to pay that funeral bill. And I also counsel people on just, even if you don't want to prepay because you have sufficient assets, it is important to talk to a funeral director about your specific wishes and really get a plan in place so that your children aren't left wondering if you want cremation or burial. And these are very, very important conversations. So if you haven't had them already, definitely have those conversations. And where should you keep your last will and testament? We get this question a lot. You definitely do not want to put it in a safe deposit box because your executor, if they're not a joint owner, cannot get into that box to get your will. And so what we do at the law firm is we have a fireproof safe that we keep last will and testaments in, and we would give you a photocopy. So we do recommend that your attorney's office keep that if possible, or if you have a fireproof safe at home, you could keep it there. And then, choosing your executors carefully is also very important. Are they going to get along? Are they going to be able to work well together? You want to make sure that you have people that are skilled in their own finances and would be able to take care of that. And one of the things we do at the law firm is when you come in for a free consultation, we ask you to bring all of your asset information. And it's not because we're being nosy. We want to make sure we do a good, thorough job at not only just outlining what you want in your will or a trust, but we want to make sure that all the beneficiaries are updated. And so we can take a look at that with what we call an asset list, where we put together a list of everything you own and outline how everything will be distributed. Okay, so in summary, probate is not a bad thing. That's not an expensive process, but there definitely are ways to avoid probate, and in some situations that would be a beneficial thing. And you just want to make sure that everything is in good order so that when you do pass away or you do get sick and need long-term care, that the people that you put in charge are able to definitely administer everything the way that you wanted it to be administered. And death and taxes is not as scary once you are educated and informed about what you can do. And really by planning ahead and staying organized, you're saving money later on. All right, so thank you guys so much for your time today. We know that was a lot of information. We hope that you found it to be very helpful. If you should choose to follow up with us and have a consultation, what you would expect at the law firm is you're going to meet with Brittany and myself from the Williamsport office, or if it's going to be in the State College office, it will be Attorney Jenna Franks and Kristen Doherty. And really what you're going to get is a team approach. So we work together to make sure that we're hearing what your goals are. We're helping develop a plan to meet those goals and implement that with you, with the team of staff members. So right now, what we're doing for appointments during this pandemic is we are trying to do as many appointments as possible by phone or Zoom like we're doing here today. And that would just be really for the initial consultation. And then we would be scheduling an appointment to meet with you face-to-face to have you sign documents, because we cannot sign legal documents over the phone or via Zoom. They do have to be in front of a notary and some witnesses. But we are doing car visits for people that prefer not to come into the office, but people that do feel like they could come into the office. We are sanitizing, we're limiting the clients coming into the office and trying to keep it as safe as possible for you and our staff. All right, so one of the important things to keep in mind about this law firm is we do offer free consultations. And I think that that is a really great thing that Julie Steinbacher has always done since I've been employed there. And it does allow people to come in and just learn a little bit more about some of the things they've heard on seminars. And really talk about their particular family, what their goals are, and get a feel for what we could do for them. And oftentimes people ask during seminars, well, what is the fee for services? And really, I can't say, because it's individualized. You know, it might be $500, it might be $15,000. It really just depends on your situation, what kind of legal documents you need or want, and really what your estate is worth too. So one of the things that you can do during the free consultation is just talk about what your goals are, and then we will outline for you specifically what your fees are for that type of work.